There it is.
Okay. Thank you everyone for being here to talk about strategies with us for challenging the particular social group standard. At the time of this recording, for those of you listening on the replay, this is 2 days after the election, knowing we're going into a second Trump administration. So it is obviously more important than ever that we're working together on strategies and being in community with other litigators. And as many of us all know, particular social groups are one of the most common claims that people seek relief for who are in removal proceedings. Now, we prepared this presentation before knowing the election, so I just want to contextualize that there's definitely an opportunity here that we're going to be walking you all through after the Supreme Court case in Loper Bright to push back against the test, and maybe we'll even see some courts more open to that after the election. But we also are going into a very dark time that we expect many attacks on immigration law and asylum law. So quite a presentation ahead. And I want to welcome and thank my colleagues, Senior Attorney Amelia Dagan, who is presenting, as well as our fabulous intern, Kaylee McGraw, who participated a lot in the preparation of this presentation. A little bit about Amica Center for Immigrant Rights before we jump in. Our focus is on defending one another. Before and after the election, we stay focused to and committed on unwavering legal defense and strategic litigation for immigrant children and adults facing detention and deportation. We believe that everyone deserves access to due process and legal representation, and we work every day to make that a reality. We believe that in this next administration, continuing to fight case by case, person by person, getting as many as people as possible lawyers who can make these type of claims is one of the most effective tools that we will have. Our lab is where we house our impact litigation. We have these roundtables every month to dig into different issues with you all, connect on strategies, and learn from you and learn from each other. You can always refer a case to us by emailing lab@amicacenter.org. I imagine many of us will be co-counseling and providing amicus briefs even more going forward into the next 4 years. So please don't hesitate to reach out. We do focus a lot on individual-based impact litigation, bringing cases up to the board and the courts of appeals. We also do a lot of work in the district courts for habeas petitions and class actions. I'll turn over to Amelia to get started.
Everyone, and thank you so much for joining us in this crazy week. We're excited that so many of you are here to talk about PSGs and kind of look to future options for our clients. So as I'm sure all of you know, a particular social group, PSG, is one of 5 options for finding a protected ground for asylum or withholding of removal, but it's not defined anywhere really. And so circuit courts have historically deferred to the board's their definition of what a PSG is under Chevron. But the question we are going to be exploring today is, now that Chevron is dead after Loper Bright, what could we do in the PSG space? As Adina noted, unfortunately, with this election, it may limit our ability to maneuver in this space. But we hope that some of the options that we present and that hopefully you will present and we can discuss together will give us some options moving forward. So I will kick it over to Kaylee to get us started.
Hi, everyone. First, I want to thank Adina and Amelia for allowing me to be part of this roundtable. I'm really grateful for the opportunity. We're going to start off with a brief history of the PSG framework, specifically addressing immutability. Next slide. As many of us are aware, an individual is qualified for asylum should they meet the definition laid out in the slide above. We want to focus on particular social groups because it's an extremely nuanced categorization. Next slide. So first we have the Acosta framework, which was in action from 1985 to 2008. At the time Acosta was decided, the BIA mentioned that international jurisprudence interpreting PSGs is sparse. Additionally, there's no definition in the Refugee Act of 1980. In Acosta, the BIA acknowledged that this would be a case-by-case analysis, but the immutable characteristic must be that one of the members of the group can either either cannot change or should not be required to change because it is fundamental to their individual identities or consciences. So, for example, this would include things like sex, color, kinship ties, things like that. This analysis with only one prong would be the framework for the next 20 years of case law. So moving on to the next framework that addresses the factors of immutability, particularity, and social distinction. So the BIA had mentioned particularity and social visibility before 2008, but didn't state that they were required. 2006 to 2008 was a bit of a limbo period. In 2008, the court adopted the framework under matter of SEG and matter of EAG. This new framework was criticized just because it created a large amount of confusion in the courts and seemed to be at odds with previous BIA case law about PSGs. For example, the PSG from matter of Kasinga relating to women who are opposed to female genital mutilation is hardly socially visible in a physical way. And there's a lot of overlap between particularity and social visibility. However, not all courts have accepted these new PSG prongs. The Third and the Seventh Circuit have declined to adopt particularity and social visibility during this time period. Next slide.
Thanks, Kaylee. And that brings us to the kind of current reigning framework, the case we are all, I'm sure, very familiar with, matter of MEVG, and its sort of sister case, matter of WGR. They both came out in 2014, but MEVG was actually interesting because it was on remand to the board from the Third Circuit. As Kaylee noted, during the SEG era, the Third Circuit had expressed a lot of concern about this framework. They said that the particularity and what was then social visibility were essentially the same thing. They were both asking, what is this group viewed as, or how are they distinct in the applicant's home society? They also noted this inconsistency with previous BIA precedent that Kaylee mentioned, and therefore declined to apply Chevron. So MEVG came back to the board, and the board attempted to, in their words, clarify the framework. And so one of the big things that they sort of clarified for everyone was that social visibility did not mean physically ocular visibility. The defining feature of the group didn't have to be visible to the physical eye. So they renamed that prong social distinction. However, even the board in MEVG noted that there was going to be considerable overlap, as they called it, between particularity and social distinction, kind of not fully addressing some of the concerns from the Third Circuit on that front. After MEVG and WGR were issued, nearly all the circuit courts adopted that framework. As Kaylee noted, many had already had, but after MEVG, even the Third sort of fell in line. The only exception is really the Seventh Circuit. The circuit has sort of never officially tangled with this issue and declined to adopt Chevron, really, but they have habitually really just applied the Acosta framework, looking only at immutability for PSGs. Next slide. So I'm sure you have many thoughts on this as well, but there are a lot of issues with this current PSG framework. Next. First and foremost, as we've sort of previewed, there is this inherent tension between particularity and social distinction. If you can define the group particularly enough to make it really clear who's in and who's out, then it's kind of hard to prove that that group is seen as somehow distinct in the home society. I think this is really well evidenced in this 10th Circuit case on the screen, where the court found that the PSG of women in El Salvador between the ages of 12 and 25 who resisted gang recruitment was sure particular. For example, 11-year-olds do not qualify, clearly 26-year-olds do not qualify, but it's not socially distinct. There was no evidence, nor can I really imagine any, where Salvadoran society would view, for example, an 11-year-old who resisted gang recruitment as somehow different than someone who fell into this group, or men in El Salvador who, between the ages of 12 and 25, as different than women in that same group. So though it's particular, it was not distinct. Next. And this tension sort of also adds to an evidentiary burden, which some of the circuit courts, including the Third Circuit, had expressed concern about. Now you don't only have to show that a trait is inherently immutable based on the fact that it cannot or should not have to change, or is some sort of past experience where that's just sort of a logical explanation of how something cannot change. Now you also have to show a lot more country conditions evidence or other record evidence to show that the society in question understands the words you're using in your PSG formulation to show a boundary, who's in, who's out. And then also that the society actually views that groups as somehow distinct from other groups or larger society. So that's a lot of extra evidence that now we as attorneys have to present. And it's hard to, as we've demonstrated, kind of thread that needle between particularity and social distinction. And if we think it's hard to sometimes come up with a cognizable PSG and then back it up with the right amount of record evidence, that battle is exponentially harder for pro se applicants, particularly those who don't speak English or who have not been able to complete as much education. They are often struggling to understand even what they're being asked to prove. What is this three-part framework? What do these words mean? It's very technical. What does social distinction mean or particularity? When if you just say, are you part of a particular social group? That's very unhelpful in asking them what to explain to the judge or what kind of evidence they're supposed to gather. And then even if they were to understand the framework, it can be hard to, as we've noted, pull the right record evidence to back up your claim and make sure that the judge is seeing that your case is in fact legally cognizable. So at this point, we want to take a brief discussion break, and you can either unmute or put in the chat. What are some PSGs that you've tried to put forward where maybe the IJ wasn't finding particularity or social distinction, or you had this struggle of, oh, now it's too particular and not distinct enough, or vice versa? Are there any other challenges that you've found with putting together legally cognizable PSGs at the trial level, particularly?
I can share some.
Please, go ahead.
Hi, this is Joanna in New Jersey at AFSC. One that sometimes is tricky is the victim or witness-based PSGs, when you have someone who's been a victim of a crime, who may have reported to police. No matter how you word it, it always seems to be very tricky, whether it's people who file police reports, people who report gang crime to the authorities in whatever country. Sometimes you want to do more than one articulation, but it can be really tricky.
For sure. Like if you say particularly, oh, it's people who made a police report, then it's a lot clearer who's in and who's out. But it's hard to prove that those people are seen as different than people who, report and witness, or who just report, but then they don't move forward with a report for like a full report for some reason. So that's a great example. I'm also seeing some in the chat, family-based PSGs. Those can be really hard. Here in the Fourth Circuit, we have the benefit of really great family-based PSG case law, but it can still be hard to prove that it's particular if you're trying to show that this is affecting a family outside a nuclear family, cousins or aunts and uncles particularly. Gang-based claims definitely in there for sure. Gang crime witnesses, those can often be seen as very particular by the home society, but it's hard to tell if that's IJs. I've heard IJs be unfriendly to that. What kind of crime? Did you have to be the victim? Could you just be a passerby? There's also one from Adriana, Salvadoran asylum seekers whose information was released in ICE data disclosure. Definitely, that's particular, but probably not so socially distinct in the home society. Elizabeth noted a client from El Salvador on the MS blacklist. Again, maybe hard to prove who's on or who's off without having a copy of any type of list or what that means. That's a good one. And then Iman, I think this is a great point about balancing PSG articulation with nexus. Sometimes there's a large overlap on trying to show social distinction, but then that sort of veers into proving that it was because of that PSG. There's a lot of overlap. For example, Iman noted women viewed as property. I agree. I think that's a strong PSG, and there's a lot of, I think, societal evidence for that. But IJs, I agree. They think that's sometimes very subjective. Women of country X, definitely. I do think that now, especially, we are potentially going to be losing some ground on gender-based PSGs for sure. Definitely. Great examples, everyone. Thank you so much. So in addition to all these kind of internal issues that you can see and through all these great examples, thank you so much again, there is also this kind of outside issue where our current PSG framework isn't really aligned with international practice. Of course, that isn't always dispositive to how the US runs things, and it's not necessarily an indicative of how things should go. But I think this disconnect is a good another reason supporting why our current framework, particularly with particularity and social distinction, is just a little unnecessary or unduly burdensome. As Kaylee noted in matter of Acosta, the board did look to UN documents or international jurisprudence to be like, what is a PSG? And at the time, there just wasn't a lot out there. But the board later did not adopt the UNHCR 2002 framework, which would allow for PSGs to be cognizable if they were based on an immutable characteristic, or social perception is the phrase that the UN used. But this was an either or option. It was not a requirement that you show both. The UN would have given us an option or would have given people an option to prove either, though they do understand that there would probably be a lot of overlap in that category. Australia kind of does two prongs, immutability and what they use as the phrase is socially distinguishable. Canada really only uses immutability. They have three subcategories of what immutable characteristics are, but they largely map onto our understanding. Something that you cannot change about yourself, that you should not have to change, or a past experience. And then finally, the EU kind of took both options from the UN and sort of put them together. They used the phrase a common characteristic, but my understanding is that it's a little bit similar to immutability and then also social perception. But from what we can see of these other options, they can see they don't have these subparts to the test that are inherently at odds with one another and in tension in the same way particularity and social distinction are.
Sorry about that. The overturn of Chevron in June has brought an opportunity to challenge the current PSG framework, specifically the particularity and social distinction prongs. Next slide. So the Supreme Court overruled Chevron in a 6-3 decision and held that courts no longer need to defer to agencies' statutory interpretation if the language of the statute is ambiguous. As of right now, most courts have adopted the 3-prong PSG framework under Chevron deference. This is largely because PSGs are ambiguous, and the court by and large found that the BIA's framework was reasonable, though some expressed ongoing concern. But Chevron is dead, so there is a window of opportunity for advocates to argue for lesser deference under Skidmore or for no deference at all. Next slide.
So since Loper Bright came out so recently, not every court has had the chance to really weigh in on this subject, much less on in the context of immigration agency review. But we did pull a couple cases that I think might start giving us a little bit of a preview about how some of these courts are going to be looking at these cases. So for example, in Aguilar, that's a Third Circuit case that came out in the context of a crim-im issue. There, the court did have a little footnote about the Loper Bright issue, didn't reference Skidmore at all, but actually in that case kind of said the court would review the issue de novo. So I'm not sure what that means for future cases, but at least worth noting that the Third Circuit is aware and will be looking at these with maybe lesser or no deference. The 11th Circuit in Perez took a look not at an immigration case, but an agency from the Department of Labor, I believe, case. There they found that the agency had been consistent for the last 8 decades or so, and that was enough to be persuasive under Skidmore. So again, that lower version of deference under Skidmore. In ARD, the Fourth Circuit, not an immigration case again, but did specifically say that they were going to apply Skidmore deference in light of Loper Bright. And so that meant that the agency decision is only entitled to respect if the circuit court finds it to be persuasive. And finally, the Ninth Circuit, in another Crim Im case in Lopez v. Garland, did look at what deference should be given to, I believe it was the definition of an aggravated felony as interpreted by the board. So not a PSG issue at all, but did specifically say they were going to be applying Skidmore. So the courts are seemingly very aware of this issue and going to be consistently applying lesser deference to the agency, which could be a window of opportunity for us.
Amelia, a question for you, just with the news of the election and knowing how we saw the federal courts respond under the first Trump administration, do you have any spidey sense or speculation about how they might go on this issue? I know we also are dealing with the makeup of the courts as another factor that's very dispositive here.
Yeah, no, I think in one sense it's a bit impossible to see which way it's going to go, and I don't want to pretend I can read all the tea leaves super accurately on this case. I do think that the fact that the courts have been so quick to kind of note Skidmore deference is probably good. I do think that there's a window of opportunity there, but I would be more hesitant to try big crazy things now and just kind of slap it under the label of, well, Chevron is dead, which maybe we would have been a little bit more inclined to do if the election had gone differently. But I do think that we should still tread carefully, but I do think that there is still this opportunity here, even with the court being what it is, and where we are definitely worried about court stacking moving forward.
So now that Chevron's dead, the biggest question is, what should the standard be? We want to hear from you, but first we want to present two options. Next slide. So the first option is a complete return to Acosta and a focus solely on immutability. One pro of this is that it's easier for pro se litigants because it's less confusing due to the lack of overlap between particularity and social distinction. This is also what the Court of Appeals for the Seventh Circuit is already doing. However, it's really hard to envision courts going back to the 80s and analyzing PSGs under immutability only.
So instead, one of the options that we think might be a bit more viable, particularly now in this post-election world, when we were putting this PowerPoint together and that hadn't been decided, but now I think that this is maybe more prudent than ever. A better option might be to argue simply that the board's interpretation to require both particularity and social distinction is just simply no longer persuasive under Skidmore for a lot of the reasons that we've been talking about this whole presentation, that there's this inherent tension between these two. It creates this sort of unreasonable burden of evidence, especially on pro se litigants, but also on us, and that it's just really hard to apply consistently across immigration judges and across particular fact patterns. So I think that the case law has also opened the door for this. Two of the cases that we wanted to highlight here in the Third and Fourth Circuits, in SERL, that was the case where the Third Circuit did apply Chevron deference to the MEVG framework. They kind of said, okay, we're going to give this a go. But the court, even there, was pretty concerned that particularity and social distinction would be applied in this arbitrary way, and they specifically even noted the evidentiary burden under this new test. The Third Circuit there was willing to extend Chevron deference, because they thought it was still reasonable, but they did note that they hoped that case law would kind of provide clarity as this framework was applied. And as I think we have seen through even the beginning of the discussion today, I don't think that clarity has really shown up in the courts. it's still hard to figure out what PSGs are going to be accepted and which ones are not. Secondly, in Amaya, here in the Fourth Circuit, the court there was analyzing whether the PSG of former gang members was viable and particular. The court there assumed that Chevron deference applied to matter of WGR, which also dealt with the former gang member PSG. But the court did say that WGR impermissibly conflated particularity with social distinction, and there was this flaw in the analysis. So that goes to show, I think, that there is a potential crack in this framework around particularity and the fact that it has this weird overlap with social distinction, doesn't seem to fit with international experiences. And so under Skidmore, there might be a little bit of a potential to kind of crack that a little bit wider open and give everyone a little bit more breathing room in PSG litigation. Though, like we've been kind of alluding to and talking about in the election, I think that this is maybe also the better option because it is a little bit more incremental. Like Kaylee mentioned, I think that trying to put forward a framework that says, let's just get rid of everything in the last decade, go back to the pre-2014 era of Acosta only, could be seen as a little too aggressive by a lot of circuit courts. And the groundwork maybe just isn't there for that yet. But it seems like at least several circuits have been laying the groundwork for at least noting the issues with particularity. What we have presented and prepared for you guys in terms of model briefing that will be sent out with the recording and slides later sort of preserves that exact issue of to say there's this issue with particularity and we shouldn't be applying it as a one of the three prongs for PSGs. Of course, at the IJ level, they have no ability to stop doing that. So it's very important that in the now, everyone keeps arguing all three prongs to keep winning your cases, hopefully, and getting protection for your clients. But it's an important issue to preserve, especially now where we might be looking at the post-Loper Bright opportunities for more challenge.
Thanks, Amelia. And in case it's like cryptic at all, the question mark next to social distinction, we're trying to just allude to really going after particularity and honing in on that and maybe just not touching the social distinction pieces. Is that fair to say, Haley and Amelia, the approach we're recommending?
I think so. I think that there's this hope that, maybe if the right case came along and if the facts were really good for it, there might be an opportunity to say, maybe the pitch is, let's pick immutability or social distinction. Either should be fine, like the UN said in 2002, and other countries also apply. But I think that the stronger point is that particularity at a bare minimum should no longer be required. And then if there is an opportunity to further down the line challenge the use of social distinction as a required second factor, then I think that that might be the better way to go at this point.
Thank you. Yeah, and to qualify what I said and clarify, the current test is the three-part test. So absolutely argue all three in the best interest of your clients. What we're really talking about is preserving for appeal. If you don't add this footnote or something similar, when you're litigating at the IJ level, it will be very difficult to challenge on appeal. So that's kind of the approach that we're recommending here. And you'll see in the model briefing, it again hones in on particularity and doesn't touch on the social distinction piece at this stage.
And there's some great chatter happening in the chat about some quotes and some thoughts that have come up even from Amaya. Bradley put in a great quote from Amaya about how particular just simply doesn't appear in the statute. It's not a requirement. And Joanna had this great note about there's no concrete defining lines, for example, for saying who's in and out of a religion. And this exact example came up in Amaya. The court there said, that the board there had said, oh, well, former gang member is kind of gray. You could have been a member for a week or 10 years. You could have been, only a lookout, or you could have been really high up in the hierarchy. So what is this? How do we kind of decide who's in and out? And the Fourth Circuit said, you could say that about religion as well. You could say the example they used was someone who's Catholic. They could be a twice-a-year Catholic. They could go every day. They could have strong seated beliefs. They could be more culturally affiliated with the Catholic Church. And so they said that this is not really a workable way, and that was a big part of their analysis there. So great points from Bradley and Joanna in the chat as well.
I want to touch on one question Joanna raised too, asking about if we see LGBTQ plus PSGs being challenged under the new Trump administration. I think that's absolutely possible. We saw in the last administration, they went after gender-based claims and family-based claims with matter of AB and LEA. So I think anything is on the table. Trying not to fearmonger or be alarmist, but after like listening to a lot of other advocates and sister organizations and different meetings in the past 2 days, I'm leaning more toward the belief of like we need to mobilize and be prepared as possible and take their word for things they say they want to do in Project 2025, and going after the whole asylum statute even could be possible in this era we're going under with the legislative power that the Trump administration will have. So again, not trying to fearmonger, but we have an advantage of having 2 months right now to prepare, and we have convenings like this and other convenings to really come together and get ready and to fight for this. So anything either of you want to add on that point for that question or anything else?
No, I completely agree. I think that, it has, in my experience, LGBTQ plus cases have been by and large quite successful. But I think that especially if we're able to keep arguing for something like the framework that we have up on the screen right now, they will keep being viable. Sexuality is, though fluid in terms of people's lived experience, it is immutable. You shouldn't have to change your sexuality in order to avoid persecution. And many cultures, I would say, find the LGBTQ community to be socially distinct. But I have heard of some rare cases, even now, where the particularity becomes an issue, actually. Especially for clients who identify as bisexual, where the concern is that the IJs will say, oh, well, the record only shows that gay people are seen as socially distinct, and this country doesn't really have a great niche for bisexuality. And so I think that this would be a much better option moving forward. Okay, I think we can go to the next slide, Adina.
So at this point, we would like to open the floor for discussion. Feel free to unmute yourself or write your thoughts down in the chat. In a perfect world, what would PSGs look like for you? And how do you think the election will impact PSG litigation?
If other people have thoughts on the LGBTQ PSGs particularly, I know that's a very big concern for a lot of our clients.
Just to tee up the conversation while folks are getting their thoughts together, and we really do want to hear from you all. This really underscores why preserving for appeal is going to be so important. That's how we were able to fight back in the last administration. So thinking the long game, not just winning at the IJ, right? But being ready for maybe your case is the one that gets taken up, and getting in the record what you can at this point. We're actually even in Amika Center thinking really deeply right now about getting more involved at the IJ level. We are starting to think about that even before the election, because that is where we can make the most impact to preserve these claims to go up.
Daniela, I see your comment in the chat about Honduran women who resist patriarchal norms. Can I ask, either in the chat or unmuted, which circuit are you practicing in? I've seen those types of cases in the Second Circuit, and I would love to see where you're having success on that.
I'm in the Fourth Circuit. So
In the
this
Fourth
is
Circuit.
yeah, this is in Maryland and Hyattsville in Baltimore.
Okay, wonderful. I think that's a wonderful offshoot of the currently reigning ARCG framework for women who are unable to leave domestic partnerships. Definitely good to take advantage of those cases right now.
I will say though that I argued that PSG under matter of AB and it was successful.
Oh, wonderful.
So, at least in Maryland, right? I mean, this is a Fourth Circuit, which is a bit more generous than others. So that's why I shared it in the chat, because maybe it'll work in the next one, but I understand that they might be even more severe. So I'm just shooting that out there as an idea for others.
That's wonderful. And I think that goes perfectly to Joanna's point in the chat, in terms of, still shooting your shot with PSGs, even if the law seems a little less friendly than it was previously. Even after the vacatur of ARCG, it didn't mean that you couldn't win on those cases. It just meant it was maybe a little bit harder. Great point. And there's really no limit on how many PSGs you can try for.
A challenge that I have is when we draw the PSGs, like I'll show up with like 12 PSGs because, we have to preserve everything, right? And then the judge wants to reduce it to like 2 or 3 because they're like, well, these are all circular. And I'm like, well, I'm trying to cover my bases here, okay? Because you may not like this one, you may like that one. Like, I just need to prove one. Does it even matter, right? Just let me phrase them however I want. How do we handle that, especially with the social distinction and the particularity, that overlap? That's like a thread in between where one of my PSGs could be correctly formulated for both. The judge doesn't like it because it's too similar to another. And then what do I do, right? If the other one doesn't meet both, how do I push back successfully when they want to do that?
Yeah, I think it's really important that you be able to say, like, Your Honor, we would like to note for the record that all of these PSGs are being presented, and especially if you present them also in your briefing, or other pre-hearing materials, because that's enough then. If it's in the record and then the IJ either just completely ignores them and doesn't even analyze them, that can be a great ground for appeal to say the judge didn't do their job. They didn't actually do all the analysis that they were supposed to do on all the PSGs that we had every right to present for our client. I think that's a great point. Sometimes, unfortunately, I think the IJs really are just going to say, I don't want to do that. Or they'll kind of chop it up. They'll say, this one fails because it's not particular. This one fails because it's not socially distinct. Bada bing, bada boom, there was no viable PSG done. And then I think that's a great ground for appeal to say they didn't analyze each PSG on its own under the whole package. So unfortunately, before the IJ, that sometimes means that you just got to say on the record, Your Honor, I would just like to be clear that we would like to, preserve all of these PSGs. And then if they don't, then that will be a matter for the board. Anyone else have any thoughts? Have you guys experienced this where judges are just asking for a couple?
I have experienced that, and what I do is I always submit like a pre-hearing brief beforehand where I articulate everything. So good luck, not letting my brief end, right? So I already said, and I'll say, Judge, for the record, I just want to articulate it, and it's also in my my pre-hearing brief. And then in my pre-hearing brief, I take painstakingly go one by one, but that's what I do.
That's a great idea. I've seen some judges specifically say in their pre-hearing, like scheduling orders, if you plan to argue PSGs, I need a separate document that just lists all the PSGs. That can be really helpful, even if they didn't ask for it. Maybe file that in your evidence packet as well. I know that before the IJ, some of our colleagues in the that are in the direct rep team, they often struggle because you only have 25 pages of briefing. So if you can, if the IJ allows for some sort of supplemental item like an articulation of all the PSGs, that would be a great way to preserve those as well, I imagine. Joanna, I like your opinion as well. You'd state on assert that your PSG is not circular, definitely. But if the IJ decides that it is, you reserve the right to dispute that on appeal. Always a great way to just get that on the record.
What is everyone's arguments, by the way, when they try to avoid entering the brief and evidence whatsoever? I usually feel like I can't say very much at that point because it technically isn't, right? It's attorney work product, but at the same time, a lot of the information that they require is presented in the brief. So if something is missed during argument or, direct, I want to point back to it, but it's not technically evidence. So for a briefing for appeal issues, I just want to make sure I'm covering myself.
So I just want to make sure I understand. So the question was, for a briefing, how to make sure it's preserved for appeal,
Yes.
essentially. Okay, yeah. So we've had that experience where sometimes, you know, as long as it's referenced in the brief, that is considered before the IJ. It's wonderful if you can reference it in a closing argument, in the actual argument. I think that really does help. But we have definitely had issues where in an appeal we say like, this was definitely raised before the IJ, see pages, whatever to whatever of the record. And then you can just show that that was submitted to the IJ, and you can pull the stamped copies off of ECAS.
Oh, okay. Got it. Thank you. I'm just getting ready because I know
Yeah.
it's not gonna be the same.
Has anyone else tried anything similar to that, proving that they presented an argument before the IJ?
No, there's one for her husband. The second or third.
I think you can. Sorry, this is Hannah Cartwright from Mariposa Legal. I think exactly what you were talking about works. I think if you really want to make sure that it gets in, you can list it as like a pre-hearing statement or a brief in terms of like the ECAS filings. And again, just have like a one-pager laying out all of PSGs. I've had various cases transferred to me where other attorneys have done that. I did want to just uplift just to be, I guess, provide a sort of alternate strategy or approach to the multiple PSGs idea or strategy. You know, I know that that became a lot more common during the first Trump administration when there was case law, you know, saying that advocates needed to preserve PSGs, or, you know, the more common practice of, you know, the board saying, well, this PSG wasn't considered, et cetera. I do think that, especially like looking at different cases where, or even cases that have been remanded from the board where there are multiple PSGs, I do think it often does muddy the waters in terms of what arguments you're actually bringing. So I do think there's a difference between like, you know, what is the core PSG or core 2 PSGs that you're bringing? Maybe there is a slight difference in wording. So maybe that, like, if there's a slight difference in wording, maybe that merits a footnote of saying, you know, this is undersigned counsel's view of the best wording, but perhaps this is something that we talk about as the parties if the core idea of the PSG needs to be rephrased and that's the PSG we want to go on. I've certainly seen multiple cases from the board where the judge has reframed, has like reworded the PSG, and that's what was discussed, right? So I think that those are options just in terms of trial advocacy. And you could also, you know, have a longer list of PSGs. And if you are lucky enough to actually be able to have a pretrial conference with OPLA, you could also say like, which of these PSGs are you willing to discuss and try to narrow them that way. But I will say when I see like a list of 10 PSGs and they're all either super similar, I'm not sure I disagree with the judges. I do think often they become circular. And I think that they end up kind of making it feel like we as advocates are throwing spaghetti against the wall and just seeing what sticks instead of really thinking through like, which PSG do you actually think, or maybe 2 of PSGs or 3 PSGs max, do you actually think is the core of your argument? Are you worried about the wording and which wording that the judge is going to care about? In which case, I think you can have conversations at trial that reflect that, right? But I don't know how many clients I've ever seen where there are actually 10 PSGs that apply. And if I were a judge looking at that, I do think that that does cause frustration and also makes me kind of doubt the claim of, you know, is this actually a strong case? Does the advocate actually know what they're arguing here or have a strategy? Or are they just trying to preserve as many options, you know, going forward on appeal in a way that's not actually going to the heart of the case? So I don't know, I just want to flag that I understand the anxiety that we as advocates have of trying to preserve the record, but I also think that we want to balance that with actually making the strongest arguments we can. So, you know, just want to put that out there, especially because I have seen, you know, multiple unpublished board cases that sort of reference some of these patterns. And yeah, I'm not sure if it's our best strategy as advocates. So that's just my 2 cents.
Thank you so much for sharing, Hannah.
I'd like to, if it's okay, just like really gently push back on that. And I think that makes a lot of sense, just to offer the opposite point of view. I spent most of my career practicing before judges who just don't grant, and they would turn off the recording and say things like, counsel, I don't grant cases like this, or I don't grant ARCG cases or whatever. And in that kind of case, where I was pretty much certain I was going to lose, it was important to me to put more than one, sometimes quite a number of PSGs in the record. Like, let's say if we're calling 3 like the not too many reasonable dividing line, sometimes I put 5 or 6 because I know this judge is going to deny. So the more more bases I have in the record, the more bases I have for appeal. And I'm not going to put forth something that is very poor, but if I can reasonably back up like 5 or 6 or 7 different articulations, I think it depends so much on knowing your judge and knowing your court. Because I agree with you that certain judges would be turned off by that. And if it's a good, reasonable judge, you don't want to turn them off. You want to work with them and have a relationship of working together. But I was in some situation where I definitely didn't have that relationship for a long time, and there was nothing I could do. So I think it's a case by case basis, your decision based on knowing your judge, knowing your court, and your circuit.
That's a great point. I am part of several like ALL listservs, and sometimes I'll see practitioners saying like they're gonna go up hearing before a new judge and kind of gatherings intel, and that could be something that would be really helpful to gather. Like, how do they respond to multiple variations on similar PSGs or anything like that? That's a good point. Thank you so much, Joanna. Or in the chat, several people have been mentioning, the power of a footnote. Definitely like maybe arguing your strongest or the kind of core ones, and then footnoting the variations if the semantics become an issue. The exact phrasing might be open to interpretation. A footnote could be enough to get you in the door on the appeal. Good point.
And on that note, for those of you who've been coming to several roundtables, you'll see that with this this model briefing we'll be sharing after, it's very, very short, just the footnote. So that's a shift we're making going forward so that you guys don't have to deal with all this template briefing. You might not have room to put in your brief that you really don't need. All is needed is the footnote to preserve it and not waive it. So that'll be our approach going forward. If you have any feedback on that, that's helpful, let us know. If that's working, we're always happy to adjust. Are there any other themes that we haven't spoken about on this topic, or questions that folks have for our presenters?
I had dropped in a note. I'm just wondering how many advocates are considering trying to push forward asylum cases before the inauguration to try to avoid some of these issues. I know that, there's a lot of times where we have very little control over that in terms of both docket issues, etc. But here in Indiana, we have the Indianapolis Immigration Court opening up in January. And so there's actually opportunities to try to advance hearings because they want individual hearings to be going forward from like January through April. And so I've begun to start trying to think through, like, for non-detained cases or even detained cases where there's complicated issues, like, is that a strategy that we should be trying to implement when we can? Yeah, I'm just trying to sort through, so would welcome any thoughts on that front from other advocates.
I just put my response in the chat. I mean, I know it's probably only so much you can control with the court schedules, but it seems like that would be helpful.
Yanni had a comment also that I think is very relevant about winning asylum cases with PSGs, but judges preferring other protected grounds. I've seen one phrase definitely repeated very often about how PSGs are not supposed to be a catch-all for every asylum, every person with a fear who doesn't fall into one of the other 4 protected grounds. So I do think that judges who are maybe more concerned about floodgate issues are going to be very much more amenable to cases that fall under other protected grounds. So definitely, PSGs are the most flexible option, but if you can also argue something else, religion, political opinion, nationality, or race, definitely please be doing that. I agree, Yanni. That's a good strategy. And Adriana, I think also a good point. PD, we don't know how long we'll have that. And so if you can get it before January, particularly if you're having issues with PSG formulation where you think it might just not work and it doesn't fall under protected grounds, prosecutorial discretion might be a very good consideration for your clients.
Joanna, thanks for sharing your comment there. Excited about the next roundtable. It's a good segue to make sure y'all know that it's going to be December 12th. So we do have to change the dates, usually the first Thursday of the month, but next month we just had to change it due to a conflict. So it'll be the 12th on records access. This is something that we've been working on at Amica Center for many, many years. We were able to secure a new nationwide policy from EOIR to increase records access and not have to go through FOIA, but is obviously not being followed very well. There's also a new online system they created in response to our demands about how there's no access for pro se people to get their records. And there's now an online system for them, but we hear also there's many challenges. So we'll be getting into the practical aspects of that. Full transparency for a second, I was thinking, maybe with the election, there's a more urgent issue. If you feel like there is, let us know. We can talk about other topics too. But it does feel like getting access to records is going to really be kind of like the nuts and bolts important stuff to fight these cases case by case. So making sure we all connect on how to do that will be important. And if you have examples to share, let us know because we can then use that in our advocacy on the Hill on this issue. And with that being said, if you have any cases that you would like to connect us to, refer to us, just email anytime lab@amicacenter.org. We're really grateful for you all being here, especially this week. It's amazing. We had over 100 participants attend. That really says a lot about our ability to come together and gives me hope on the community we can keep building on the roundtable. So I'd love to hear too, if you have a second in the chat, do you want us to do more in 2025? This was kind of a beta thing for us this year. So we only planned it out to till December, but do people want to have more roundtables continue as a space for us to strategize together? If yes, maybe just put like a 1 in the chat or a yes. Okay, cool. I'm hearing some yeses. Awesome. So we'll continue. Let us know. Feel free to email me, adina@amicacenter.org, if there's topics you want to cover. We want it to be as useful as possible. So thank you so much, everyone. Thank you, Amelia and Kaylee, for doing an amazing job. Kaylee would have never known that you're an intern from that presentation. It's so impressive. Thank you, and thanks for everybody's insights and strategies they shared. Take care and stay in touch. Thank you.